Hey there again, my name is Aisha Ochoa and I'm super excited to discuss business with you once more. Now, if you have been following, you will know that there was an introductory video where I introduced my new book, General Contracts in Commercial Transactions, and also broke down in details 26 different contracts that you will come across in your day-to-day activities in business as a visionary leader. Now, if you have not watched the video or read the book, I advise you get a copy of the book and you tune into the video series and watch them. Power-packed videos explaining different types of contracts that you will come across in your business, irrespective of the industry you're in. Now, if you have not already come across this contract, it means you're doing something wrong, because you must come across at least a few of these contracts in your transactions. It is extremely important for you to familiarize yourself with all 26 contracts because they may come in handy. In fact, you ought to have encountered a few of them already by now if you have been in business, or even if you are new to business, because you cannot go into any agreement verbally, right, with anybody, because it will just be your word against the person. So you must understand the different contracts and the roles they play, the different times you can apply them, the different transactions they are for in your commercial transactions, in your daily activities as a business owner. So get the book, right? Read the book. Make sure you familiarize yourself with everything about these contracts. In the book, I broke down the definition, the uses, the importance, and the legal implication of each of these contracts. My agenda today is to break down 4 important points you must understand about commercial transactions and contracts. The first is the ethos of a contract. The second is the role of a contract in commercial transactions. The third is the common mistakes to avoid when entering into a contract. And the fourth point is the importance of legal advice in commercial transactions. Let's start with the ethos of a contract. The ethos of a contract are the ethical principles that must govern both parties' activities when entering into a contract. Now, this involves fairness and integrity, clarity and certainty, mutual benefits, confidentiality, because sensitive information may be shared in the course of the contract. So both parties should have the mindset of protecting each other's confidential information, right, in the course and even after the contract has been completely executed. It also governs the respect for autonomy, because each party should have the free will and the right to make choices as regards the terms and conditions, obligations, responsibilities, and expectations of the contract. So when drafting a contract, one party should not have the upper hand while the other party is at a disadvantage and is forced to agree to terms because the other party has the upper hand, right? So there should be respect for autonomy. There should be room to make choices and to disagree with terms, which will now make both parties meet at an agreeable and on a mutual ground. The ethos of a contract also demands that both parties entering into the contract must intend to comply, adhere, and obey every single term and rule set out in the contract. So you cannot, enter into a contract already bearing in mind that you're going to default the contract. No, that's not what the ethos of a contract provides. You must enter into a contract that you intend to keep. If you do not intend to keep that contract, if you do not intend to obey the rules and regulations of that contract, then you have no business executing the contract in the first place, because you will only end up breaching the contract and attracting legal consequences to yourself. So having understood the ethos of a contract in commercial transactions, it is important for you to understand the role of a contract in commercial transactions. Now, contracts are usually entered into to spell out the expectations of both parties, plain on paper, right, readable and understandable, presentable to the court or to another party in the case of a dispute, right? So that's the number one purpose of a contract, to define the terms of the engagement of both parties involved in a specific transaction. Now, a contract is also entered into in order to prevent the risks of misunderstandings. Now, when people discuss about a project, some information may be left out, maybe unintentionally, right, or even intentionally, because you really cannot know the heart of man, right? Certainly in business, when it involves money. So some information may be left out, or some facts may be misrepresented, different things can happen in the course of just normal discussions about a business, but when it is spelled plain, broken down into clauses, and expectations are stated, there will be a high level of understanding between both parties, because both parties can read in plain English, right, or whatever language is applicable, the terms of the contract and know what they are getting into before they sign. So it is going to help reduce the risk of misunderstanding in commercial transactions. A contract also provides legal protection for both parties involved, because having spelled out the terms, rules, and regulations, and having affixed the signature of each party, anything contrary to what was stated in the contract will result in a breach, which is actionable in court. So both parties involved in the contract understand their position, right, both in the transaction and under the law, especially when they default on any of the terms stated in the contract. Now, having understood this, you know that it is important for you to draft a contract before you enter into any transaction with another party, especially transactions that involve money. Of course, commercial transactions involve money, so it's just smart for you to have a well-drafted and properly executed contract that has been perused by a lawyer before you execute, right? So it's important for number one, the contract to be properly drafted. Number two, to be reviewed by a lawyer. Thirdly, for it to be properly executed, because if the contract is not properly executed, it may not be binding, right? And that will be subject to interpretation of the courts. Having understood the role of a contract in commercial transactions, let us explore some common mistakes that people usually make when entering into a contract. The first mistake people make is not clearly defining the terms and conditions of the transaction in the contract. Don't leave anything to guessworks. Don't leave anything to thin air. Make sure you properly spell out every expectation from that transaction. Spell out all the rules and regulations, the terms, the restrictions, every single thing about the transaction. That is the essence of drafting a contract in the first place. So what's the point if you're not going to make sure the contract captures everything you have in your head? Put everything down on paper, write it plain. That's the only way the other party will understand what you intend towards the transaction. Another mistake people make is not accounting for change in the contract. Make sure the contract is flexible enough to accommodate changes. It could be a change in a clause, right? Make sure it's flexible enough not to affect every other clause in the contract, because laws change every time. So if the law that governs that transaction changes, what will happen to the legality of every other part of the contract? That's the way some smart lawyers will make the whole contract void. So make sure the contract is flexible enough to accommodate change. Let there be a clause in the contract that, only invalidates the particular clause that the law is against, or the particular voidable clause in the contract, and it doesn't affect every other clause in the contract. Another common mistake people make is not providing a termination clause. A contract must provide for grounds upon which a party can terminate the contract even without breaching the contract, right? So make sure that every contract you sign has a clause for termination, because nobody knows what may come up. A situation may come up that may demand for you to opt out of that contract. So you make sure there's a termination clause that gives room for one party to opt out without it literally affecting the other party. A contract must also follow the law. So make sure that all existing laws that govern that transaction are being considered before executing or before even drafting a contract. Review all the laws that govern that transaction. Make sure that the transaction is in compliance with the law, and make sure the contract is also, drafted in accordance with the provisions of the law. Now, one terrible mistake people make when entering into a contract is not ensuring that both parties have signed the contract. Make sure both parties sign the contract. One party should not sign the contract and then expect the other party to sign without confirming. Because if the other party does not sign the contract will not be binding on the party. So if a party sends you a document, right, asks you to review the document and sign, after you have signed, make sure the other party sends you the final signed copy. That is the only way to confirm that the contract has been properly executed. Don't just sign your own part and send to the other party thinking that, okay, all good as signed, we're good. Make sure you verify that the other party has signed and sent you the final copy. You must have the copy that has the signature or the seal of both parties, not just one party. That is the only way to confirm that the contract has been properly executed by one party. Otherwise, a contract binding on only one person is not binding at all. Now, the very worst mistake anyone can make when entering into a contract is not having the documents reviewed by a lawyer. Before you sign any contract, make sure a lawyer reviews the documents for you. The lawyer may just say something that you will never see. The lawyer may say something you're not even aware of, because it's the person's job to know the provisions of the law. So how about you give the contract to someone whose job it is to know about contracts? Give it to a lawyer to review, to ensure that you are not signing your burial in business. Because there are people who have signed contracts that have taken them out of business. There are people who have signed contracts that have cheated them in so many ways in business. Make sure the contract is reviewed by a lawyer. Now, this brings me to the importance of legal advice in commercial transactions. You can never quantify the importance of legal advice in commercial transactions. Lawyers are very knowledgeable. Get a lawyer that is versed in your field. Now, there are lawyers that do general practice, right? They can advise you on everything, every aspect, every industry. Now, there are also industry-specific lawyers that engage in commercial transactions, lawyers that are major in oil and gas, lawyers that are major in accounting. Look for a lawyer that best suits your needs and make sure you onboard a lawyer in every commercial transaction. Have an in-house lawyer. It's really not expensive, because the cost of remedying wrongs is more expensive than the cost of getting a lawyer in your corner. So make sure you get legal advice in every commercial transaction, so you are sure that negotiations are airtight, you are sure you are getting the best out of every deal and the appropriate advice before you affix your signature on any document. That is the best way to be a smart and a visionary business leader.